One issue, as far as the GPS monitor and all that, they gave him a new device just now. They said it was a charging issue. They plugged it in, it would charge for 10 minutes, stop charging. He has a brand new one they just put on this morning.
I
Now, the
got
drug test issue,
violation that he's out at 3 in.
well, no, it's not that he's out, is that that's when it reconnected. But they gave him a brand new device. And they're saying there was an issue where they changed it out and there's not a tamper on it. It's just, it said it was not receiving. It didn't say it was that he was out and about. It said it wasn't receiving, and they started receiving again. That's at least the report that I saw. It's not like they were tracking him other places. But as far as resolution,
Okay, pause for a second. This part is super important. The defense is clarifying that the GPS alert didn't mean the defendant left his house, but that his monitor just stopped receiving signal. That might sound minor, but in court, technical glitches like this can make or break a probation violation case. So, what do you think? Should a charging error be treated like a bond violation?
case, I did talk to him, and he is interested in participating in DWI court. And I know because we talked about that last week, and I had visited with him on that this morning.
Says here on 3/11/24, GPS device generated a failed to enter alert at 10:15 p.m. At 11:46 through 3:02, GPS device was in no GPS no cell status and was unable to be monitored during that time frame. Client arrived home at 3:01 a.m. on 3/12.
So that's not when it arrived home. That's when it started charging again. Because it's not a geolocate. I mean, as far as I'm understanding, it's the GPS shows where he is,
I'm
not.
going to be honest, Your Honor, that would be a question for
Oh,
pre-trial.
no, I'm sorry. It's pointed to the client, not to you.
Okay, I was like,
Saying out and that he's out in the middle of the night.
I don't think they're saying that. What they're saying is that it's received a no signal.
Client arrived home at 3:01 a.m. on 3/12.
Where was he before that?
Huh?
They don't know where he was before that. He was at home. He just wasn't charging.
You have.
That's the way I'm reading it.
Do you have?
Right
Do you
here.
have the idea of where he is?
Like, I don't see any notes from the case manager, and then at 10:05, I see on the report, it's showing that he's not at his home location. So I think that would be the fail to enter. And then there was the portable violations as well that were added. But again, from what we discussed earlier, I don't, necessarily have to go forward.
Portable to violation in what respect?
They sent an email yesterday from the supervisor that was here earlier, stating that there were additional.
Who's, did Anthony send that?
No, it would be from Cody Pittman.
Okay, so
Or this specific one is from Luis Galvan.
So I also have here, client was also instructed to obtain a portable alcohol testing device.
Wow, you can really feel the judge's frustration here. This isn't the first time this defendant's been warned skipping drug tests repeatedly after multiple chances. That's a direct challenge to the court's patience. And look how personal the judge gets, saying, "All I want is for you not to kill anyone." That's heavy. He's not just sentencing, he's pleading for accountability.
Comply with all testing protocols, refrain from alcohol consumption, and comply with all routine equipment service. The defendant failed to provide breath samples, scheduled times, resulting in 13 skips from 2/7/25 to 3/17/25. So he's still skipping tests. Come up, Mr. Jones. I just don't get it. I truly don't. It's over and over and over. You are still skipping tests. And I don't know what it is and what I need to do to get you to comply with bond conditions. You're still skipping tests. I mean, I have no other choice. I now have to revoke your bond again.
All right, well, let's do a plea then.
Huh?
Let's plea it.
I agree with, and I'm okay, but I'm going to tell you now that I want to have him TRAS'd immediately to see how we go forward.
Well, Judge.
You know,
Okay.
just all I want you to do is not kill anyone, man. That's all I want. You know, really, I'm not asking for much. You have since day one in our court have repeatedly refused to comply with bond conditions over and over and over. And I'm not doing a plea to where he can just get out and just do, and
So,
you scare me,
so how do we resolve, it, Judge?
huh?
So how do we resolve it?
So, yeah, I agree with you. I think that the correct thing would to do would be probation.
Okay.
But I would like to have him TRAS'd while he's in there. And I have a feeling I know what the TRAS is going to say, and that's what I would like to do.
Okay. I would request you to set a bond.
Of course.
It's just costing him money, Judge. Already it's costing him is his family money.
So it's okay to just skip tests?
No, it's not. It's a test, but I'm saying
It's a
is
skip. I might just be asleep, but I'm not trying to skip him, Your Honor. I swear to
just
God.
stop talking. Yeah, I don't, you don't,
Sure.
just stop.
Okay, he goes, and it's literally, the minute he gets out, we have bond violations over and over and over. Now, what are we now, day what?
If the court wanted to be made aware of the presumptive results,
What did he test positive for?
THC, Suboxone, Oxy, and benzodiazepines.
He tested positive for OxyContin?
Yes, Judge, presumptively positive, it's being sent to the lab for the test issue.
What I had envisioned, what I think is probably do like a 2-year probation. I want to do like maybe 10 days as a condition, do an immediate TRAS. We'll get it done today, tomorrow, and we'll see what the TRAS says. And I'm going to go with what the TRAS says. If the TRAS says, and I promise you, Dustin, I will do what if the TRAS says that IOP, SOP is the proper course, then I'll do it,
Okay.
you know? But if they say residential, I think that that's, I want to follow what the TRAS says because I think that that's the proper one.
I don't think you can take it.
Hmm?
I just don't think you'll take it if it's residential.
Then I have a jury waiting right now.
You should have said it. I mean, let's just see what it says. Let's try to get a quick TRS done.
For sure.
How quickly?
So do you want to do the probation?
Yeah, he wants to do probation. Judge.
Okay, let's do it. Okay, Blaze, you let me know.
On,
Jones, probation.
okay, yeah, I mean, we had offered the probation first, so, yeah, it's TRS.
So,
Okay,
so probation,
2 year.
TRS conditions.
2-year.
Okay.
I want to do 10 days as a condition. That way I can get the TRAS done now immediately while he's in. And then I'm going to follow whatever the TRAS says. Are you Dad?
Yes.
How are you?
Fine.
Thank you so much for coming.
Can I say something?
First, go with Dustin first, because I don't want you to say something that really, just,
No.
just,
No.
please. Yeah, you guys can talk and then later on, if it's, then,
Thank you, Judge.
thanks, Dustin. All right, come on out.
All right, so what we're gonna do, Judge, is he's not gonna bond out. We're gonna reset it for she said she'd get a TRS done in a couple days. I got him, he wants to see what the TRS is gonna say if he recommends DWI court, because that's kind of what he wants to do. Pretty much I think he'd be more successful in DWI court. So let's get the TRS done.
In sober court,
It's a-
he just wants to be out, so he doesn't have to be in custody, but the
Oh, no,
problem
this
is,
is gonna be, this is gonna be in your court.
it won't be in my court.
I understand that.
So
He's TRS done, but he's not bonding out. Dad's not bonding him out. I told him he needs to sit and have TRS done, and they can get it done. So I'm gonna reset us. What, 5 days, Tuesday, and we'll have TRS by then. He's not gonna bond out because we're not bonding out.
You want to talk?
Yeah, I don't want him on. I suggest I don't want.
I get it. I understand.
why.
I understand. I understand.
So, we'll do five reset for Tuesday next week, then they have TRS done by then.
Okay.
This is where courtroom reality meets human resistance. The judge and defense both know what's coming, a recommendation for inpatient treatment. But the defendant's already shown he can't stay clean while free. It's that classic tension between giving one more chance and protecting the public. What would you do if you were the judge here, treatment or straight jail time?
All right.
Hey, Judge.
Okay.
And I'll get the.
So we're not doing a plea today, but hold on. Dustin, come on up. I want you to know that if it says residential treatment
Understand?
and he's no, I mean, I'm setting this case for trial,
Absolutely.
right? And I'm not gonna,
Are all full straight probation?
I understand.
Okay, cool. I heard for.
No, he was asking.
No.
It's not legally, it's not legally possible.
my concern is that what I feel is gonna happen is when he does a TRAS, they're gonna say residential, and he's gonna say, I don't want to do residential, I want to be out. When we know, based on here, it just doesn't work when he's out. He does what he wants to do.
If he
The
doesn't.
hell with the
If
conditions.
he doesn't want if he doesn't want what the TRS recommends, then he'll take a jail sentence, and that's just what it is.
I'm not gonna take that. I'm not taking it. I'll send for trial. I'm not taking notes.
He'll plead to a jury and do jury punishment, and he'll get a jail sentence. Like,
You can do what you want,
he's not
but
probation eligible for a jury. You can't force that probation. Let's say the TRS.
no, I think I can. I mean, I think I can. I mean, I'll look the code, but
If I do jury punishment, you can't. Like, you see what I'm saying? It's like, I do
I
jury
mean,
punishment.
sure.
You can't.
Sure.
But I'm not trying to. Let's just get the TRS and see if we can help, because you want, yeah.
Dustin,
I know what, dude, we're on the same.
giving
I know you.
him a jail sentence of 20 days, 30 days, 60 days solves nothing. It literally throws him out into the wolves, and he's just gonna pick up a felony DPI within the next 30 days, 60
Let's see what
days.
the TRS says and see what we can do.
I'm trying to help this kid, man.
I know you are.
And just a straight jail sentence it's within a year, he'll have a felony DPI.
I understand. I mean, and you know I understand. You know we're on this.
All right, so let's see what the TRAS says and it's pointless in argument. I agree. Let's just see what the TRAS says. We'll have from there.
Take your.
Mr. Reynolds, sir, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 10th, 2025, officers were patrolling the area of the 13,500 block of Beechnut Street, Harris County, Texas. And they observed a white Hyundai Kona with an aluminum pole stuck to its hood due to a recent crash. A traffic stop.
What?
A aluminum pole stuck to its hood.
An aluminum pole stuck to the hood of a car.
Yes, Judge.
That's the basis for the stop.
Yes.
Okay.
This is word for word what when I observed a white Hyundai Kona with aluminum pole stuck to its hood, comma, recent crash. I then got behind the vehicle and yep.
Yeah, keep going, please.
Okay. I went back and got behind the vehicle. The officer started speaking with the defendant, who admitted to being driving and that he had crashed. The defendant told me that someone swerved into his lane and crashed into the pole. The defendant stated that he already called his record and that he was good to go. The defendant did not show any intentions of going back to the original scene and gave his information. While the officer was talking with the defendant, a security officer told the client that some people flagged him down the street, saying that the defendant crashed into multiple parked vehicles and drove off. The officer detained the defendant and went back to the original scene, which was a quarter mile from where the officer found the defendant.
Now that adds to it. I mean, that's certainly.
The officer spoke with a witness who stated that he was by the front of the apartments when he saw the white vehicle losing control, crash into a pole, and kept on driving while hitting another two vehicles. The witness stated that he was going around 60 to 70 miles per hour in a 35 mile per hour speed limit zone. This confirmed how the aluminum light pole got stuck to his hood. The witness stated that he did not see anybody else around the vehicle before the incident. The officer spoke with one of the owners of the vehicles that was struck, and she stated that it will be around $200 to fix her vehicle and wants to pursue charges. The complainant of the other pickup vehicle had damages to the back right part of that vehicle, and the complainant stated that the defendant crashed into her vehicle and left without providing information. The defendant left the scene without, okay. At this point, they called intake, and then they completed an inventory search of the defendant's vehicle and located a black backpack with 7.4 grams of marijuana, multiple clear plastic bags, and scale.
Is he under arrest? I mean, if he's under
So
arrest,
they
then,
called,
but I didn't hear that he's under arrest or anything. They just up and go start searching.
They did say that the officer called DA intake and spoke with an EDA who accepted charges of the FSGI. And then it states there was an inventory search conducted.
Okay, so they did arrest him but what happened? Because is there an FSGI charge?
We're gonna be honest, Your Honor, I'm not entirely sure what happened there. I'm working on it right now. If there's FSGI, right now I'm working on complainants. We can get things worked out that way.
I mean, I don't
Right now, we do
understand.
not have an FSGI charge at this very second.
Did they accept it or did they not accept?
Based on the DIM statement, it says that we accept the charges. So I am trying to see why there's not a charge, but it's not something that we know.
What a weird day so far.
Your Honor,
Can I say something? Your Honor?
No, don't. Now's not the time. I'm gonna give you a lawyer and you can tell your side to the lawyer, but
I think it was a glitch in our internet system, so they could find marijuana, but they just, wherever, yeah, that's charged.
is it going to go through? Do you know?
I need to look into our system, our insurance, to figure out why it didn't, if force comes to worse, we can make it a grand jury. But
So I'll give you, I guess, let's do this. I'm gonna appoint him a lawyer today and I'm gonna find probable cause for the moment, but I want to revisit it within the next couple of days to see what is going on. And then, all right, so I am gonna find probable cause for now, Mr. Reynolds. Can you look to see if he has a license, please?
Yes,
Driver's
Judge.
license. How old are you, Mr. Reynolds?
I'm 26, sir.
His driver's license is not eligible, Your Honor.
You're not allowed to drive. I don't care what's going on in your life. I don't care if you need groceries. I don't care if you need this, that. If you don't have a license and liability insurance, you're not allowed to drive. No, I will give you a lawyer today. You can say your side to the lawyer, but if you don't have a license and car insurance, you're not allowed to drive. Do you understand?
Yes, sir.
That is a condition of your bond. If I find that you do, I will revoke your bond, put you in jail, no more PR bonds for you. So what I can have you do is I'm going to have Deputy Miranda give you an application. I'm going to have you fill it out. I'll have you talk to a lawyer today. But unless I guess let's do that. I'll have you talk to the lawyer and then we can revisit the situation after you talk to the lawyer. Please.
Sir.
Hi, Judge.
Hi, bud.
Approaching on Reynolds, I think, reapproaching on PC, I believe. He's over here on a possession of marijuana. She said you wanted to reapproach, so that's what I want. It seems awfully fishy. I'm not sure why they detained him for FSGI. I do not understand that.
Well, I mean, I think that there's a valid claim for an FSGI because someone says that there's a guy barreling through a neighborhood, hits a bunch of cars, takes off. We have someone that puts him there, right? That
Yes.
says it's him. My concern is that they say they accept charges for FSGI, right? But we only have a POM.
I understand.
I don't get it.
I
Just-
understand. That makes no sense to me either.
So what I did was I found probable cause for now. I'm gonna give them another couple days to figure out what happened. Why was it a
Did it all
glitch in the
work?
system?
It just for what it's worth, according to my client, he was on scene. He wasn't away from the scene. He was by his car when they were arrested.
See us?
Way away from the accident.
Well, the accident happened and the car went forward and hit something. Anyway, it's okay. But
Show me.
either he's FSGI and they can prove that he belonged to that marijuana, or they can't prove that he
So
belonged to that marijuana.
let's do this.
That's fair.
Why don't we set it for a formal probable cause?
That's fair.
Days, you pick it, I don't care.
Next week, okay?
Sure.
Okay, sure.
And then that gives them enough time to also look into
Gotcha.
what happened with the FSG, why is it not, you know?
That sounds fair.
In the interim though, come up.
Mr. Reynolds?
You tell me he doesn't have a license, right?
It is not eligible, Your Honor.
I have here that he's trying Uber or something like this.
That's correct. That's my
He can't
understanding.
drive. You don't have a Texas driver license, right?
Come over here.
No. It's a yes.
Do you have a valid Texas driver's license?
Have a-
Yes, as far as I was aware.
They're looking into the Texas.
I understand what
system
that just
because
said,
it's
sir.
not valid.
Right.
So you don't have a license.
I understand that now, sir.
You can't drive.
I understand that,
Don't
sir.
drive.
Yes, sir.
If I find that you drive, I'm gonna lose it.
I
I'm
understand
telling you
that,
now,
sir.
I will put you in. Because all I'm asking you to do is follow the law. I'm not asking much. If I find that you're driving, and I don't care what your excuse is, I don't care if it's a burning building and you have to say 50 kittens, I'm gonna lose it. You will be signing a promise with me. This is an affidavit that you're gonna promise me that you're not gonna drive. Do you understand? It can go really sideways if you do. All you need to do is contact DPS to figure out what you need to do to get your license back. I'll even give you the phone number. Let me stick these-
I already have that information.
Oh, there it is. I always
Yellow,
lose
you want blue?
it.
He's gonna give it to you. Just let him give it to you. Call me this afternoon and we'll figure out why it's not valid.
So this is the number to the driver's license division, the DPS. When you call them, call at 7 in the morning. Don't call at 9, at 2, at 1:53. You'll never get through. You have to call when the phone lines open up, give them the number and ask them why it's no good, and they'll tell you.
I need the SR22.
Oh, well, there you go.
I had
Then you know why.
Oh,
almost, I was just working Uber every day, so I didn't know.
But so you can't do that. Don't worry. You don't need to say anything else. He's got it figured out.
look, Mr. Reynolds, do not drive. Do you understand?
Sort it
Yes,
out.
sir.
And you need car insurance before you drive too.
Oh,
Just, we'll fit. Fine.
Okay.
We're gonna be back next week, so we can answer like just next week. Or between next week, I'll answer them. All right.
gotcha.
Hopefully you can get that sorted out. Come back, that thing says eligible, you'll be good to go. All right? Then he'll lift that restriction, I think is what he's saying.
Okay, come on up, Mr. Reynolds. We'll have you sign this and then you'll be free to go. Good morning, Mr. Ibarra.
Good morning, sir.
So you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, this is a under 21 UCW. I can still read you the facts if you would like. Okay. On March 3rd, 2025, an officer was dispatched to a shooting. The officer found the defendant in a back alleyway with a gunshot wound to his leg. The defendant had a mesh backpack in his possession at the time and was able to see that there was a black handgun inside. The caliber of the handgun matched shell casings located on the ground next to the defendant. The defendant stated that he shot the gun in self-defense at 3 black males who shot at him. Those suspects fled the scene after officers' arrival. The defendant was transported to Ben Taub Hospital where the defendant was being treated for the gunshot wound to his left femur. The defendant admitted to being in the 114th Street Bounty Hunters gang and is 18 years old.
Okay, so was it really that, did he shoot himself or do we know that someone else shot?
We do not know. We
So-
know that the casings on scene match the caliber of the handgun that he had, but we don't know if he had shot himself and he stated he was being shot at by other people as well. So it's unclear.
So the only allegation is that he's underage, essentially. Okay. Mr. Ibarra, I'm going to find that there's no probable cause to go forward in your case. You need to be very careful. You get but one life. You know, God forbid something happens where you have a gun and you use it and then you end up getting charged with something. You've gotten shot in the leg now. I mean, luckily it's not somewhere else. It could be life ending.
Sir.
When you hang with dogs or when you're bad places in the middle of the night, really do something with your life. Get into school, graduate, get some knowledge.
Sir.
Take a seat with me.
I have Ms. Salmaron on the docket, Celia Salmaron.
How's she doing?
She did a T-RAS. It looks like they're recommending like the women's residential. Yeah.
Yeah, that's a good idea.
So the issue, Judge, she needs to be on a probation. She has 2 open PCSs currently.
No rush, really.
She's
That's probably the appropriate thing.
okay. So her felony court date is March 28th. And the problem is that I just, so she has the old PCS, but she has a new one. And, she's not going to be able to bond out. The felony court did give her bonds, but she's not going to be able to afford those. And
What are you asking for?
a trial date. My problem is, Judge, it could take months and months for them to get the lab back on the PCS. Or I can get a
Do they have
reset.
the last back? I mean, how long?
I'm sorry, I didn't catch.
So-
Salmaron.
Okay, okay.
Yeah, it's an old case, Connor, you're right. I didn't realize it's from May of last year.
It does appear that the labs are still pending.
Yeah, is it really gonna take that long to get? I mean, how long do you think it'll take? Do we have any, are the labs back on the first case?
Yes, Judge, I think they are, because I think they're in connection with this DWI.
Have you evaled? Are you ready?
I'm ready. I mean, I was ready before she forfeited, so.
The labs are back on the second case.
It's the same case as our case. Yeah, I have no idea how long it takes to get labs back. You don't know?
No idea.
We have an offer in there. It's an old case. We can set it for trial today if that's what you want to do, Judge,
It's not
but
me, it's Connor. I'll do whatever you want. It doesn't matter to me. If you want to set it, I'm fine. If you want a little bit more time, I'm fine with that too.
Yeah,
You tell me, you're in the driver's seat.
I think that, so she has court next Friday. If we could get just a couple week reset, see what happens next Friday, see if they get the labs, and then if not, then we can.
And, perhaps have her see how long it'll take.
Yeah, and I'm gonna
Ask someone else.
I'm gonna reach out to her felony attorney and then maybe the prosecutor, see if we can't work out something.
Global,
Yeah,
that or ask them, hey, how long does it take? If it takes 6 months to get a lab back, I mean, that's unreasonable.
yeah.
I'm with you at that point. So,
for the time being, I'll put an eval to do it for us.
For sure.
Next setting meeting.
yeah,
Sounds good. Thank you, Judge.
for sure. Morning, Mr. Eli. Coming up. How are you? I know you don't want to go into treatment, right? And I acquiesced to you last time. You asked me, please, I can get it done. Please don't let me do it. Don't put me in residential. Don't. And I listened. And what happened? No. Yeah, you caught a felony DWI, not. We put you on probation. A month and a half later, you pick up a felony DWI. So all this acting. So now, if this doesn't show that residential is the right thing, then I don't know what does. The only thing that we're trying to do is prevent death on our roads. That's the only thing, right? And somehow we have to get through these. Every other way that we've tried just doesn't work. This is the only other thing that we have left at our disposal. So if you want, we can just set it for a hearing. And if they prove to us that you have violated your probation, then we're going to amend your conditions to put you in residential treatment. We can do this any number of ways. We can have a full-blown hearing, or you can just sign the conditions. But if they prove it to me, that's what's going to happen.
I'm not signing the conditions.
Okay, so set it for a hearing, and then get the probation officer here, and then we'll see. And then they prove to me that you have violated your probation, then I'm going to amend your conditions. I'm not letting you go. Ever. Do you understand? I'm going to keep you until we get this straightened out, one way or the other.
Okay.
Understand? Okay,
That's it.
good. So I'm at your mercy when you want to set it. You want to do a week? We can set it in a week and then just have a hearing. It's just at the mercy of the probation officer, whatever they are best with. Okay? Good morning, Mr. Bacana.
Morning, sir.
So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay.
Complainant and defendant are in a former dating relationship. On 6/29, officers were dispatched to a disturbance at a business in Harris County, Texas. Complainant entered the business, and when she exited and walked back to her truck, she observed the defendant there. Complainant believed defendant had followed her. Complainant said that defendant was intoxicated and started to insult her. Complainant stated defendant struck her on the left side of her face with a closed fist as she sat down inside of her truck, causing pain. Complainant stated she went after defendant as he entered his truck and grabbed his shirt. Complainant stated she was momentarily dragged as she held onto the defendant's vehicle.
So it was a hit to the face, you said?
Yes, Judge. We have not been able to arrest her yet. I will let you know that I was reading through the offense report. I don't know if this was mentioned to intake, but in the offense report, it does look like she was 4 months pregnant at the time and the defendant was aware. So this maybe refiled as a felony. I'm not sure yet, but it's where we're at right now.
Mr. Tejada, I'm going to find that there's sufficient probable cause to go forward with the case. I'm now ordering you not to consume alcohol, illegal drugs, unprescribed controlled medication. If I find that you're using, I will revoke your bond, put you in jail. I'm going to do everything in my power to protect my public at all costs. Do you understand?
Yes, sir.
You are not to have any contact with the complaining witness in this case, not to be in possession of weapons. And I'm now entering what's called a magistrate order for emergency protection. This is a court order that identifies Ms. Lopez Leiva as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Sir.
If you violate this court order, the state can and will probably file a violation of protective order, and that is the capital murder of misdemeanors. It is one of the worst cases you can pick up, a violation of protective order. Do you understand?
Sir.
You pick up one of those violate conditions, I can have a hearing to hold you at no bond, zero bond, and I'll do it in a heartbeat to protect my county. Any prior assaults against this person or?
No, Judge, this looks like it was the first one.
Okay. Now, you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Parham. If he tells me he can't get a hold of you because you've gone AWOL, I will issue a warrant for your arrest. You pick up a new case, I will issue a warrant for arrest. You get no more PR bonds. Do you understand?
Yes, sir.
You will be randomly called upon to go take drug and alcohol tests. If you fail to go, then likewise a warrant for your arrest will be issued. I'll have you go sign a reset with Victoria. You'll sign the order for protection here. You'll get with Felicia for your bond conditions, and after that, you're free to go.
Just,
Oh, is there no bond set?
well, no,
Oh,
it's
there
a
is.
bond set, Judge. With regards to the bond conditions, I was wondering if we could, amend those or have them reflect the no threat and harassing communication, instead of no contact. They do.
They haven't been able to reach her.
They haven't, but the DA hasn't, but that she has spoke with her back. And she had spoken to the back and told her that she didn't want to proceed with the case. She would,
I don't know. I mean, if she's 4 months pregnant,
no, she's already had the child. They already have a child now. That's the only reason why I say now.
Yeah,
because
this did happen back in June.
They do have a,
If,
child.
let's do this. I want to know, I mean, if that VAC was done, that VAC was done in 2024. I don't know anything recent. So until I know what she wants now, then, and if you could, facilitate, perhaps give a phone number, maybe that's something that can happen now. I don't know, but I like to follow the wishes of the complaining witness, and I don't know what her wishes are. If she doesn't want contact with you, then I'm gonna order it. If she does, then we can revisit it at that time. But understand, for this instant, no means no. It doesn't mean maybe. It doesn't mean I got to go get my kid. It doesn't mean someone has to go take the SAT. No means no. Do you understand?
Sir.
Okay. All right.
Thank you.
Thanks, guys.
Judge.
Good morning, Mr. DePaz.
Good morning.
So you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot.
School resource officer responded to a security officer needing assistance in LaPorte High School. Upon arrival, the defendant was placed in the security resources office after a physical altercation. The defendant stated he was upset with the complainant because the complainant had mistreated his sister in the past. The defendant confronted the complainant and struck the complainant with a closed fist on his face. The defendant was observed on school CCTV walking up to the complainant and punching him with a closed fist, and shortly after, the complainant fell to the ground. The complainant did not show signs of confrontation towards the defendant. The complainant was observed with multiple lacerations on his lower lip and a missing tooth from being struck in the face. The complainant was also observed with a swollen jaw and bleeding from his mouth, and the complainant felt pain. I have spoken to the family of the complainant. He's had to have his jaw wired shut. His jaw was broken on both sides of his face.
Serious bodily injury?
I don't believe that would rise to the level of serious bodily injury because it's not permanent disfigurement, because he will heal eventually, but it will take 6 to 9 weeks.
Mr. DePaz, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're smoking weed, if I find that you're using alcohol, I will put you in jail. You will get your degree with me. Do you understand? You are now not to go back to LaPorte High School. I'm ordering you not to go back. I don't want this person to live in fear, so you're not to go back there. Do you understand?
Yes, sir.
If I find that you become a danger to my community, I only have one place for you.
Yes, sir.
You're not to be in possession of weapons as well. You were what, 17?
Yes, sir.
Okay, I will provide you a lawyer today. I'm sending you for a drug test. I want to know what, if anything, is going to be in your system. You're to take a test and you're to come back, and then I'll have you speak to a lawyer.
Yes, sir.
If you don't go take the test, if you don't come back, I will issue a warrant for your arrest.
Yes, sir.
I know it's your problem. You got out of jail because we gave you a free bond. You're not going to get another one if you're a danger to my community.
Yes,
You
sir.
understand?
I'm not causing.
Okay,
And Judge, did you say no contact with the complaining witness?
Correct.
Okay.
but don't worry, don't file anything because I'm going to have him supervised.
Okay.
All right, so just reach out to the night for him, please, and then I'm going to send him for a test right now.
Okay. Well,
Rand, how are you? Right, how are you? Judge looks very festive today.
So this is an FSGI, am I right?
Yes, sir. Hola, yo te voy a interpretar, ¿ok?
Good morning, Ms. Reyes.
Díaz, señora Reyes.
Good morning.
Ms. Reyes, you're charged with failure to stop and give information. Essentially, leaving the scene of an accident without exchanging information.
Escena de un accidente sin intercambiar la información que necesitamos hacer.
You are facing up to 180 days in jail
180 días en la cárcel por
and or a $2,000
una
fine.
multa que no sobrepase $2,000.
We are going to do probable cause.
Soldados,
You have the right to remain silent. Anything you say can or will be used against you.
para contra usted.
I insist she stays silent.
Y tu abogado insiste que se quede callada.
Just please go slow.
yes, Your Honor. On March
El
10th,
10 de marzo
2025,
del 2025,
officers were
los
dispatched to
oficiales
Safer
fueron
Street
a
and
una calle Safer
Seth Street in reference to an
Street.
FSGI.
bajo una referencia de faltar y dar información.
The officers were
Los
advised that a white Charger left the
oficiales
scene
dijeron que
following
un
an
White Charger
accident
se fue de la escena después de un accidente
and was last seen
y
going
lo
southbound
vieron
on Shaver
y iba
Street.
en camino al sur en la calle Shaver.
The complainant stated that she
quejante
was
dijo
traveling when a
que
white
ella estaba
Dodger
manejando
made a
cuando un
unsafe lane
Dodger
change
Cambió de carril, pero sin
and collided with her.
y chocó contra ella.
The complainant
El
showed
quejante
officer a
dijo,
picture of the
Él
suspect
tomó
vehicle,
una foto del vehículo y le enseñó
Which
al oficial
showed the license
y
plate
tenía la
and
placa.
damage to the vehicle
y
on
el
the back
daño al
left
vehículo.
portion. The complainant
El
estimated that the
quejante
damage was
dijo que
around
él
$1,000.
está estimando que cuesta como $1,000 en reparación.
Officers ran the
Y los
vehicle and
oficiales
found the registered
Vieron la
owner to be
placa y
Juan Maneno.
encontraron que el dueño era Juan Veneno.
The officer located the vehicle at the apartment complex
Encontraron
that the
el
vehicle was
vehículo
registered
en
to.
los apartamentos a donde estaba registrado.
The officer met with
Y
Juan
el
and his
oficial
wife, who's
habló
the
con Juan y
defendant.
la esposa, que es el acusado.
Juan advised the officers that the
Y Juan
defendant
le
had been
dijo
driving
que
the
el
vehicle all
acusado
day,
estaba
and that
manejando todo el día el vehículo
and that the only damage to the
que
vehicle should have been on the
daño
front bumper from a
que
previous
tenía el
incident
vehículo
and
era
nothing
en la
else.
parte de frente de un accidente previo.
The defendant
Y
advised
el
officers
acusado
that she was
le
driving the
dijo,
vehicle and
ella
had
estaba
recently
manejando
gotten back from a Walmart,
el vehículo y había regresado
which
de
is around
Walmart
700
como
feet from
como
where the incident
700
occurred.
pies de a donde ocurrió el
She denied hitting
incidente
anybody.
y ella negó pegarle a cualquier persona. negocié.
Your Honor, so based on the
Y basándome en la
information, the
información dice
car was registered to his wife.
So, how do we know who's
And
driving
the
it?
complaint,
y
the
cómo sabe quién
Juan
está
stated that
manejando.
he was the one driving and she admitted to being in that location at the time.
She denied hitting, right? Do we have any kind of evidence that puts her at the scene that she's the one that causes the accident?
Que ella estaba ahí y causó el accidente. Go ahead.
That she was the one, within 700 feet of the accident and that she had
Estaba
access to the vehicle, Your Honor.
Tenía acceso al vehículo y estaba 700
And this
pies
vehicle was the one that was in the
del lugar.
accident.
Y ese fue el vehículo que estaba en el accidente.
Did you say that the husband said that she was driving it?
She was
Que
driving
el
it all day.
esposo
Your Honor.
dijo que estaba manejando.
statement.
Dice que sí.
You want to add anything? Did you want to say anything?
No, well,
Yeah, yeah,
two
yeah.
things, Judge. Number
Dice
one, there
dos.
was no evidence that
No hay
she was,
evidencia.
as you mentioned, there was no evidence that she was
Que ella
driving the
estaba
vehicle. And just because she had the vehicle all day does
Solo
not mean she
dice
was
porque
driving
tenía
it.
el vehículo ese día.
For example,
No
when I'm sure my
significa
daughter's
que estaba
home,
manejando.
I'm sure,
Porque cuando,
and she's
por
using one of our
ejemplo,
vehicles, I'm sure that
mi hija
her
estaba
lunkhead
usando,
boyfriend is probably driving it the majority of the
vehículo
time.
puede ser que
Additionally,
no,
this
el novio de
vehicle
mi hija
is
estaba
insured.
manejando. Ahora el vehículo
There's
está-
never been
tiene
any
su- está
report
asegurado.
of anyone,
Y
but
ningún
people had
reporte.
consent to driving it. That defense is not going to be erased, so this is
Y
an
eso-
insured incident.
It's just,
Es un incidente
you
de-
got A, you got C, but you don't have B. I mean, I just don't think that,
A ver,
officer could have gone to Walmart, pull video, see her coming out, other
pueden ir a Walmart a ver si
cameras anywhere else. I don't know, but I just,
no hay
I
prueba.
don't think there's enough.
Okay. Sure.
All right, I'm gonna find no probable cause in your case,
Va a
man.
encontrar que hay motivos fundados para mantener, pero
Please be careful when you're driving.
ten cuidado con
If you're going to drive, do not drive unless you have a valid license
no manejar
and liability insurance in your name.
y seguro.
Do you understand?
¿Entendido?
Okay, all right.
And she does.
Yes.
For the court's edification.
Thanks, Jamie.
Always great seeing you, and I apologize on the record for calling it my future son-in-law is a lunkhead, in case that goes anywhere. I forgot it's being videoed. All right, take care.
The pause?
I keep